Hey everybody, this is Christopher Small with CMS Law Firm. We do estate planning, we do probate, we do it well. Today, I want to talk to you about whether or not you are required to formally read the will after someone dies. And before I get to that though, if you have questions about this, if you've lost a loved one, my condolences, but if you need help, if you have more things to do with that, if you need help with yourself, please go to estatemeeting.com. You can set up a time to talk with me over the phone or in person for free. estatemeeting.com. Okay. Now, this question it's not one that I get a lot. It's one that I saw sort of out there on the internet, and I was like, it's kind of interesting thing to talk about. Something that people might be wondering about, but they don't really know. And what we're and I think this sort of comes from watching movies and seeing like these movie scenes that are created when someone dies, where the whole family gathers, nobody's looking at the will, nobody knows what's in the will, and then they sort of like dramatically open the will and read the will, and typically in the movies, at least, someone's surprised because they're cut out. Someone else is super happy because they get a whole bunch of stuff, and drama ensues. So the good news and the bad news, I guess, because wouldn't we all like to have some drama in our life, is that you are not required to read the will when someone has died. Although there is what's the word I'm looking for? It's required, I guess, is what I'm trying to say, for everyone to get a copy of the will that's in the will, and everyone that's an heir is also required to get a copy of the will eventually, assuming that a probate is opened. So there is the opportunity for everyone to see that will eventually. What is required, however, is within the first 40 days of someone dying, if they have a will, you are supposed to file it in Washington State, at least. You are supposed to file that will or record that will with the county. Okay, and it can be really any county in Washington State, but you have to go record that. It costs $20, and they have a will repository where they store all of the original wills for everybody in the state. That's a law. I can tell you, to be honest with you, sort of in full disclosure, if you don't do that in time, there really isn't a penalty. If you don't ever do it, there really isn't a penalty. But if you do have a will and you're going to open a probate, you're going to have to file that will with the court eventually, so you might as well do it early on. Another thing to note is that when you do record that will, it does become a public record, so everyone can have access to the will via that public record, whether or not you ever open a probate and then are required, or I guess it's the nice thing to do to send everybody a copy of the will. So that's it. That's the question, or that's the answer. No, not a formal reading of the will is not required when somebody dies. However, there are some requirements that you want to take note of and follow. They're there for a reason. They make everything easier. They make everything, the process go smoothly. So I would encourage you to do that. But once again, I'm Christopher Small. I'm the owner of CMS Law Firm. We do probate. We do estate planning. We do it well. If you have questions about this or anything else related to estate planning or probate, please go to estatemeeting.com. You can set up a time to talk with me over the phone or in person for free. estatemeeting.com. As always, thank you so much for your time. I appreciate you. If you are listening to this somewhere where you can subscribe and you don't want to miss any of these future videos or podcasts, go subscribe. Otherwise, thank you for your time. Thank you for your attention. I hope this helped you out. If you have any other questions or anything in the future, please let me know. Otherwise, have a great day, and I'll see you again soon.